Today, I'll be covering different options or choices for what your divorce process can look like. It doesn't necessarily need to be the traditional each spouse hires an attorney and go to the courthouse process. Options range from no professional assistance to court litigation and trial, and I will be explaining those options in this webinar. So the process choices fall on a spectrum. On one end, there's 0 to little degree of professional legal assistance and a high degree of privacy and personal control. On the other end of the spectrum, there's a high degree of professional legal assistance and less privacy and control. And most cases fall in between on this spectrum, and there could be a hybrid of processes, particularly if one process is not successful. So in terms of options or choices, I will be covering these processes divorcing couples can choose from, beginning with least to most on the spectrum. So the first one will be no professional assistance, legal or otherwise, unbundled legal services, and then mediation without attorneys, collaborative law, and finally, the traditional legal representation process. So first, I'm going to talk about these two options together, no professional assistance and unbundled legal services. Basically, the couple is resolving the divorce themselves directly with each other, with or without legal advice behind the scenes. In terms of the no professional assistance option, the couple needs to discuss all issues and come to a resolution between the two of them directly. And so issues that need to be agreed upon are asset debt division, parenting plan and child support if there are minor children, and potentially spousal support. So for this process to be successful, the parties or the couple must be able to communicate well. There needs to be a certain level of trust, no imbalance of power, and the couple needs to be comfortable and feel safe to express what they want and why. And there needs to be a level of emotional maturity so that strong emotions are not interfering with reasonableness and the ability to communicate and be reasonable in considering different options to resolve the issues. There can't be any challenging financial or parenting issues. So for example, if one spouse wants to be the primary residential spouse, or if each spouse wants to be the primary residential parent and for the other spouse to have limited residential time with the children, that's hard to overcome without outside intervention. Another example is when a spouse is completely in the dark about finances and assets and debts. And so that spouse will not have the information and ability to negotiate without some sort of assistance. And then finally, the parties or the couple needs to be able to research, at least one of them, and prepare divorce documents and to present them to the court on their own. There are forms available to download and to use. And some counties, there's a family court facilitator that can assist in providing proper forms and walking you through the procedure to present divorce documents to the court. Now, in terms of pros and cons to this process, there's no or minimal attorney's fees. There is a level of privacy, and potentially there would be less conflict, particularly conflict that comes along with litigation. On the flip side of that, it could also cause more conflict. It could kind of go either way, because when you have a divorcing couple having to communicate directly, while it may minimize litigation if an agreement is reached, it could increase the conflict they have between each other. They're forced or they're having to negotiate directly. And a con to this process is that you or your spouse may not be properly educated in terms of what you are entitled to under the law, or you may feel inappropriately pressured by the other spouse. And so that could result in one spouse agreeing or being forced to agree to a worse outcome than the court would order. So unbundled legal services can go hand in hand with couples trying to negotiate directly or resolve their divorce privately on their own. So these services consist of one spouse or each spouse consulting with an attorney as needed. And so the spouses can't consult with the same attorney. If both of them want to consult with an attorney, they would have to go and consult with a different one. But essentially, that attorney is working behind the scenes, assisting the spouse. And this does reduce attorney's fees as compared to hiring an attorney for full representation. And you can choose to disclose to your spouse or not disclose in terms of what would be best that you are consulting with an attorney. The attorney is limited to assisting with what you specifically ask for. So if you are asking for specific legal advice or asking specific questions, the attorney will provide that specific information or advice requested. The attorney can also draft or review paperwork if that's what you ask for, although the attorney's name is not on the paperwork. So essentially you're paying for whatever work or assistance you are requesting from the attorney. So unbundled legal services can help to alleviate some of the issues that come with the process of having no professional assistance, but you need to consider and think about what questions to ask and what information you need to know, because the attorney is only providing information and advice based on what limited information you're giving them. And so that attorney is somewhat working in a vacuum based on what is relayed to them. The next option is mediation without representation or without attorneys. So mediation is when the parties are not able to directly resolve their divorce themselves, and they need someone to help facilitate an agreement. And so the mediator is one neutral person. It can be a lawyer. There are companies that provide mediation services. It could be a mental health professional, and the spouses need to agree to this neutral person, and that person, the mediator, will try to help the couple reach an agreement on all issues. And so the couple and the mediator sit in a room together and they mediate directly face to face with the mediator's help. Now, the mediator cannot give either spouse legal advice or advocate for either side. They may or may not draft the divorce agreement or final divorce orders, and they generally are going to recommend that each spouse consult with and have an attorney review any agreement reached and the final divorce orders. So for mediation without representation to be successful, both sides need to know generally incomes, assets, and debts, but perhaps not at to the same level as if they were doing it themselves without a mediator involved. The spouses cannot have opposite positions on parenting issues, although a higher level disagreement can be resolved with the mediator involved than without. And again, there needs to be a level of emotional maturity and willingness to listen so that unreasonable emotions do not interfere with the process. And there needs to be an equal playing field. There can't be any controlled dynamics involved. So this option is more expensive than having no professional assistance, but you receive the benefit of a neutral person helping to navigate the process of reaching an agreement. It's also less expensive than traditional legal representation with attorneys. A negative of this option is there's no advocacy on the part of either spouse. And so, although there is some level of neutral education the mediator provides to both parties in terms of the law. The next option is collaborative law. Now, collaborative law is a formal process outside of the court system, and the spouses must agree to utilize this process. And this is not to be confused with each spouse hiring an attorney and the attorneys working cooperatively. This is something different. So in collaborative law, each spouse has to hire a trained collaborative lawyer. And there are trained attorneys here at the firm, including myself, but it can't be an attorney who's not trained in this process. And the parties and their attorneys agree to work together respectfully, honestly, and in good faith. And the goal is to address legitimate needs of the spouses and their children, if they have any. There's no hiding the ball or taking advantage of the other side in this process. And this process consists of negotiations, which are done in four-way settlement meetings, about a handful of them. So the spouses and their attorneys attend these meetings, and you're sitting all in a room together. And the length of the process depends on the complexity of the issues and what's involved or what needs to be addressed. But there's no negotiating in terms of or any settlement terms outside of these meetings. Everything is done in these meetings in terms of negotiating and reaching an agreement. But the focus from the very start is on settlement. So the attorneys, again, cannot go to court or threaten to go to court. And if the process fails, the spouses need to go and hire new lawyers if they intend to file a court case and litigate in court. In the collaborative process, the lawyers guide the negotiations. They provide legal advice, but the couple is the one that makes decisions and agrees on final solutions. And these solutions can be creative to the benefit of the couple and their children, if they have any, and of their family. It doesn't necessarily need to be what the court would decide or what is provided under the law. The process also includes a formal collaborative divorce team. So of course the attorneys, but then you can also have a neutral financial specialist, a divorce coach, a parenting coach, a child specialist, and other specialists if they're needed, such as appraisers for real property or other assets. So aside from the attorneys, the team is jointly retained by the spouses. The financial specialist compiles necessary documents and information to be able to prepare an asset debt spreadsheet and come up with different scenarios in terms of division of property. The divorce coach helps with teaching the spouses to communicate effectively and managing strong emotions so they don't interfere with the meetings and the negotiation process. The parenting coach helps the parents to create a parenting plan that meets the needs of their children. And the child specialist focuses on the children's needs. They're there to bring a light into what is best or what the children need. And they can also explain how the divorce is affecting the children. Now, these are just possible people that can be on the team. Not every case needs all of these specialists, and maybe your case just needs one or two of these people. But ultimately, the spouses and their attorneys during a meeting agree on the source of funds to pay for the attorneys and the team. And this is critical because neither spouse's access to legal advice or funds is disadvantaged because of the issue of having funds or being able to pay for attorneys or other people that are needed in the case. Now, most cases that utilize a collaborative process to settle is generally less expensive than litigating in court and going to trial, but of course it's more expensive. It generally is more expensive than the other options that I've already gone through. So finally, I'm going to talk about conventional or traditional representation. And as I'm sure you know, each spouse chooses and retains their own attorney, and their attorney is responsible for advocating for their position. There's no agreement in terms of how the divorce process is handled or negotiations conducted. That's really generally up to the attorney. The attorneys and the parties do need to follow court rules. That includes formal discovery, such as subpoenas and depositions to obtain necessary information. They need to follow court-imposed case schedules and deadlines, and that potentially could mean trial many months out, if not a year out, for the date of filing. However, the attorneys and the parties can agree to work cooperatively, and they can agree on a timeline for the case. They could agree to exchange necessary information voluntarily, and that would all help to reduce attorney's fees as well. Under traditional representation, negotiations are generally done via counsel. There's no direct contact between the parties, although the spouses aren't prohibited from talking to each other. Generally, in divorce cases, you're required to mediate, and under traditional representation, that's done via a settlement conference. And so in a settlement conference, it's different than mediating without attorneys. In a settlement conference, each spouse with their attorney is in a separate room, and the mediator goes back and forth to help both sides come to an agreement. There's generally no contact between each side. And mediation could happen early on in the process, or it could happen closer to trial. There is a deadline to mediate. Generally, it could be 10, 11 months out before you're required to mediate, but counsel and the spouses could agree to mediate earlier. So there are tools in a traditional divorce case involving traditional representation and filing in court. You could have parenting evaluation conducted if custody is an issue. There could be appraisal of real property or other assets, appraisals such as business or unique assets that may need to be appraised. You could have tracing or valuation done by a CPA if that's needed. And of course, this will have their own separate fees associated with whoever is involved with doing that kind of work. And sometimes it's necessary to have that type of work done. At the end of the day, if there's no agreement after these tools are utilized or the information that needs to be discovered is completed, then you go to trial. And trial is generally what is most expensive in terms of divorces. Now, that being said, over 90% of cases settle. And it's just the timing of when there is settlement is what can increase fees. So because you're doing work, attorneys and any experts involved are doing work from the time the case is started until it settles or going to trial. And this may include prepping for trial if you don't settle until the eve of trial. So the longer the case is, usually the higher the fees are. Now there are benefits to traditional representation, particularly if there's an emergency situation, such as a spouse or children are in an unsafe situation, a spouse is being cut off from funds or not being allowed to see their children. The spouses can't continue to live together and there's no agreement for one party to move out. So in that scenario, a spouse can seek court intervention right away and ask for emergency or temporary relief or orders. And so in that situation, you have the tools to be able to do that quickly and have the court make a decision, particularly when safety is an issue. And then ultimately, sometimes there's just no choice. Like the parties don't agree to utilize another process, or the dynamics make it impossible to work together. So if you're thinking or in the midst of a divorce, it would benefit you greatly to think about which of these options is the best fit for your situation. There isn't a right answer. You can discuss with your attorney when interviewing or hiring one, and you can consider discussing these options with your spouse. Knowing your options and having a say in which process is used puts you in control and makes you better able to navigate divorce in a way you want to, and that's best for you and your spouse. It could also impact the final outcome, including your future relationship with your spouse, particularly if you will be co-parents moving forward. So thank you for watching this week. This is my contact information if you want to reach out with any questions, or if you want to schedule a consult with me or any other attorney in our family law group.